Unmute. 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 Unmute.
Mic check. Check two.
Check 3-4.
Unmute. Unmute.
Mic check. Check two.
Check 3-4.
Unmute. Unmute.
Mic check. Check two. On the record, this is the evidentiary hearing in file number EO 2023-0448 in the matter of the application of Union Electric Company, DBA Ameren, Missouri, for acceptance of its triennial filing of cost estimates for Callaway Energy Center decommissioning, including the independent spent fuel storage installation and approval of the funding level of the Nuclear Decommissioning Trust Fund. I am Ron Pridgeon. I'm the regulatory law judge assigned to preside over this hearing. It's being held April 29th, 2025 in the Governor Office Building in Jefferson City, Missouri. The time is about 9:03 a.m. I would like to get entries of appearance from counsel, beginning with Ameren, Missouri, please.
Good morning. Thank you, Your Honor. Appearing on behalf of Ameren, Missouri, Jennifer Moore, and my business address is 1901 Choteau Avenue in St. Louis, Missouri, 63101.
Ms. Moore, thank you. An entry on behalf of the staff, the commission, please.
Yes, thank you, Judge. This is Travis Pringle appearing on behalf of the staff, and my contact information is in the docket.
Mr. Pringle, thank you. Any entry on behalf of the Office of the Public Counsel?
Yes, Nathan Williams, Chief Deputy Public Counsel, appearing on behalf of the Office of Public Counsel and the public. My address is P.O. Box 2230, Jefferson City, Missouri, 65102.
Mr. Williams, thank you. Any further entries of appearance? All right. Anything from the bench or from counsel before we proceed to opening statements from Ameren, Missouri? All right, hearing nothing. Ms. Moore, when you're ready.
Good morning. May it please the Commission. I'm Jennifer Moore representing Ameren, Missouri. The stipulation and agreement in this case is reasonable and should be adopted by the Commission and approved. As an initial administrative matter, the parties in this case agree that the customer contribution should be reduced to zero. In docket ER 2024-0319, the Commission recently, in the company's most recent electric case, the Commission approved the stipulation in settlement wherein the parties agreed to adjust the customer contributions to the nuclear decommissioning docket to zero based on the order in this case. So the Commission, we are going to need an order relatively soon so that when the compliance tariffs are filed, maybe by Friday, they will reflect a zero contribution. And as a procedural matter, I don't think any of the parties will object to the Commission issuing an order, reducing those to zero, and then ruling on the two contested cases at a later time. But just so the Commission is aware of the timing of that. And it's predicated, reducing it to zero and having the electric tariffs reflect zero is predicated on a ruling on this case that the contributions be zero. Now, in terms of the contested issues, again, it's reasonable for the Commission to adopt the stipulation and settlement. The record reflects the company relied on the assumption asset mix of 65% equities and 35% fixed income, as well as those tax implications in the modeling that projected the balances all the way out to 2044 for the Nuclear Decommissioning Trust. It's reasonable to reflect the fact in the final order, and it should be noted that the Commission's orders in the triennial reviews have reflected investment assumptions since 2012. The Commission first started detailing this in docket number EO 2012-0070. As reflected on page 9 of the amended attachment 4, the analysis demonstrates that allocation of 65% equity and 35% fixed incomes offers the highest probability of success to ensure that the nuclear decommissioning is already funded. And it's important to note that the analysis that ran through the stochastic modeling did consider those tax implications with that. And so this is a reasonable assumption. It's a factual item in the record, and it's reasonable to reflect that in the order. Now, the Commission rules provide that the investment manager should invest the qualified tax trust assets in the non and the qualified trust so that and I'm kind of phrasing here, in a manner that is designed to maximize the after-tax return on the funds invested. So, and then the rule goes on to say, you know, what the trust manager can invest in and not invest in. So if we look at that, and I'm sorry I couldn't get that bigger, we look at that, the blue part of the pie, that 245 million is the customer contributions. And so this is a realized gain, meaning the taxes have already been paid on that customer contribution portion. And I can't read it, but I think, you know, that other portion, I think it's like 500 some million dollars there, and that those are the realized gains, meaning this portion of the trust has already been taxed. The larger 717 million is the unrealized gains. So these assets have not been taxed yet. So in other words, it's like appreciated equities that the stock value has gone up. And so when you break it down, the light blue pie is the 143 million that if you cashed out that 717 million today and reallocated it to a fixed income, that you would have to take 143 million off the top. And all of that is as unrealized gains, and that portion of the trust goes to the federal government, that 20%. So that off the top, you're not going to be earning any of that on that 143 million as you go on as you go down the line up to the decommissioning estimated time of 2044. So these are the tax implications that haven't been discussed, and that the commission should, well, they have been discussed, and if we cash it out today, the settlement reflects that total value amount, but the investment opportunity of that 143 million is lost if it's reallocated as the OPC kind of suggests. And so I think looking at the OPC's position that the commission doesn't need to acknowledge the fact that we have relied on this assumption in the record, but I think it's reasonable to do that because it allows the commission a transparent roadmap and allows them to understand why we are projecting and using a more, some people wouldn't say aggressive approach, but a more projecting it to hold on to those equities longer and not transfer them into a fixed asset. So it's not clear to me whether the issue is just not recognizing the fact of the record in the commission order, or if there's a broader underlying issue that the OPC doesn't like the asset mix and thinks it should be changed. But the fact of the matter remains, there's been no analysis on those tax implications if the asset mix was changed, and our projections, like I said, would be 67% probability that the funding levels will meet the decommissioning as the time for decommissioning comes in about 2044. And so that's one of the issues. If you reallocate the funds, if you reallocate any of those funds today, they will incur a 20% tax on that. And so, again, I don't think there really should be an issue here. I think it tells a good story of the customer contributions and how much they've earned in realized and unrealized gains, and customers are benefiting from reducing the amount to zero and allowing all of the earnings to keep pace with the cost of decommissioning today. So consequently, I think that the commission should approve that aspect of recording that fact in the order. Regarding the second contested issue, it's reasonable for the commission to allow the company to commit to a trigger, just so that if there is a deficit that starts growing between, maybe they're down the road, there might be a spike in the decommissioning costs and the growth of the fund might not keep up with it. Is it likely? Probably not, but in the event it does, we've found a buffer, a reasonable buffer that would allow the fund to continue growing but be matched by ratepayer dollars so that that asset could be available at the time of decommissioning. If you allow the deficit to continue to grow and don't readjust the customer contribution, customers in the future will be paying more because, as the gap widens. So, and again, it's important to know that this doesn't put the OPC under any obligation. OPC is not a signator of the commission, and it doesn't bind the commission in any way. The commission is under no obligation to approve additional contributions on that band. They may hear other evidence. The commission will review the facts and circumstances, and if it doesn't support renewing the customer contributions, then the commission is under no obligation to allow those to continue. So with that, Judge, Commissioner, Chair, I think it's good reason for the commission to go ahead and adopt the stipulation and settlement as it is today. And thank you. Are there any questions?
Ms. Moore, thank you. Any bench questions? Any
I have one, Judge.
When you're ready, Commissioner.
Who manages the trust fund on behalf of Ameren? Does Ameren hire a fund manager, or does FERC have a fund manager, or how does that work?
The bank, it's BY Mellon of New York is the trust fund manager. So we do retain a trust fund manager that manages all of the holdings and ensures that in the event that some of those holdings grow beyond the 65% prescribed for the rules, it's at that time that they will sell off those securities and reinvest it into the fixed income. And Mr. Deschler will be able to answer additional questions.
Thanks. And my other question was the 2044 decommissioning target is a trigger that's set in the license agreement. Is that correct? There's no expectation that we're going to decommission Callaway in 2024.
That is correct, and I think the company's been clear that they want to seek and have taken steps to relicense the plant, to extend that license. The issue really is that at this time, it's 10 years out from, we haven't made an application to the NRC at this point. It'll be 10 years out from the decommissioning, and then it will take that time. So we really won't know until about 2038, 2044, if the NRC will grant the license. At where we stand today, it's looking good. However, I wish I had a crystal ball, but I can't. But, for all intents and purposes, yes, there is a commitment there to go ahead and seek relicensing.
So these securities would be invested throughout whatever that period is, and it may be well longer than 2024.
That is correct.
Okay, thank you.
All right, Commissioner, thank you. If there are no further bench questions, right. Hearing none, opening statement from staff. Mr. Pringle, when you're ready, sir.
Good morning, Judge Pridgen, Chair Hahn, Commissioners, and may it please the Commission. My name is Travis Pringle, and I'm appearing to you today on behalf of the staff. Staff's position in this matter is that the Commission should approve the non-unanimous stipulation and agreement that was entered into between staff and Ameren, Missouri, and filed in this docket on February 7th, 2025. As Ms. Moore pointed out, there are contested and uncontested issues before you today. I will skip my summary of the uncontested issues. As Ms. Moore pointed out, all the parties agree that that $0 contribution should be ordered by the Commission. However, regarding the two contested issues, whether it is reasonable for the Commission to order, 1, the current trust fund allocation, and 2, a trigger amount that would permit Ameren, Missouri to request resuming customer contributions. As a signatory to the non-unanimous stipulation agreement that included those two terms, staff believes it would be reasonable for the Commission to issue an order with those two terms being addressed. Regarding the current allocation of 65% equities and 35% bonds, as Ms. Moore pointed out, that has been included, that allocation, in prior Commission orders regarding the Nuclear Decommissioning Trust Fund. Staff further believes that it is reasonable for the commission to include that in this order because it is also in compliant with commission rules. And as Ms. Moore again pointed out, it has been included in prior commission orders going back to 2012. As for the trigger, staff believes that it is reasonable for the commission to approve the trigger provision from the stipulation, which would limit Ameren Missouri's ability to request a resumption of customer contributions to the fund only if the balance of the trust becomes deficient by $50 million from the projected cost of decommissioning. This does not mean that staff agrees that those customer contributions should resume in such a situation. This simply provides a guardrail for the company to come in and request the resumption of customer contributions. Once they make that request, staff will conduct its usual analysis and determine whether a contribution is reasonable at that time. Again, this term does not bind anyone saying that contributions will resume if that $50 million trigger is hit, simply that the company can then come in and request the resumption of customer contributions. Staff witness Randall Jennings is taking the stand today to answer any questions you may have regarding staff's analysis in this case. He authored staff's recommendation and also submitted rebuttal and surrebuttal testimony in this matter. If you have any questions regarding staff's analysis, please, I implore you, ask him. And thank you for your time today, and if you have any questions at this time, I'm happy to try and address them.
Right. Mr. Pringle, thank you. Any bench questions? Chair Hahn.
I do, thank you. If the $50 million trigger was hit, the company could then request for customer contributions to restart. Would that be after a full hearing?
So yeah, it would be the same process.
process.
As we're going here with the triennial filing. They would come in saying, at least my understanding, they would come in saying, hey, we now have a $50 million or more deficit regarding what the estimated cost of decommissioning. We believe customer contributions will resume at this level, and then staff would conduct its typical analysis.
Thank you. I think I recalled that after I asked it from Ameren's, the stipend agreement and citation to the appropriate statute, so thank you.
Yep.
Chair Hahn, thank you. Any further bench questions? All right, hearing none. Mr. Pringle, thank you.
Thank you.
Opening statement from Public Counsel, Mr. Williams, when you're ready, sir.
May it please the commission. My name's Nathan Williams, and I'm appearing here on behalf of the public and the Office of the Public Counsel. Everyone agrees that there shouldn't be additional customer contributions to the Decommissioning Trust Fund at this point in time. Not all parties agree as to exactly why that is the case. I mean, at this point in time, there are sufficient funds in, or assets in the fund that as long as the fund grows enough to account for any increase in decommissioning costs that might incur in the future due to inflationary pressures, to cover that. So in our view, it's actually more than fully funded, because if you were tracking customer contributions to try to have them evenly spread out over the life of the plant, which originally was 40 years, which would have been 2024, because of a 20-year extension, that's now 2044. So we're talking about an additional of roughly 20 years. So in theory, at least, earlier customers have over-contributed. There should still be, if it had been ideal, you would still have customer contributions going forward. But because the fund has all of the amounts that it needs to, like I said, other than inflationary pressures, to cover any escalation in costs for decommissioning the plant at its end of life, the assets are there to cover that. So what should be being done is the purpose of the asset allocation is to conserve the principal in the fund and then just grow it enough to cover any escalation in decommissioning costs. And we're talking about for the next 3 years. Actually, I think they're going to file in 2026, but you look at this every 3 years to make sure you're tracking things right. actually did a pretty good job for hitting the 40-year mark. There wasn't a de-escalation or a reduction in the contribution amount from customers whenever they got their 20-year license extension, so arguably there was over-contribution. But the reason we're opposing the asset allocation is we think, well, one, the rule caps it at 65% equity, so they can do whatever they want. What we're really saying is that you shouldn't be coming back to customers for additional contributions unless something really radical happens. I mean, you miss some huge cost at your decommissioning study or something else. Customers shouldn't be responsible at this point, based on what we currently know, for adding more money to the fund. As to the $50 million collar, that's until the next filing, which is, I believe, in 2026. And, you know, 50 million is nowhere even close to what would be an appropriate level, because right now you have all the funds, you should have all the funds you need in terms of the corpus to go ahead and grow that fund to have sufficient monies to do the decommissioning in 2044. Ameren included something in the settlement agreement. It's not on the list of issues, but they're saying they want funds that are retrieved from the DOE that customers contributed to UE and then UE paid to DOE for a central storage, nuclear waste storage facility, Yucca Mountain. I think probably everyone's heard of that. Well, Yucca Mountain never came to fruition, so there's been legal action and a requirement that the funds be returned to the utilities that paid them, and then they should be flowed back to customers. What UE is saying, what they put in the stipulation is that that flow back of funds would be applied to the costs of the local storage facilities, the nuclear storage facilities on site at Callaway they had to build because Yucca Mountain didn't happen. Then the other part they want to be contributed to the decommissioning trust fund. We don't agree with that. I mean, the fund has sufficient amount in it currently, assets currently. It should be conserved. It shouldn't be being managed to grow it. And by grow it, I mean, we're not saying don't have any equities in it. We're just saying you don't need to, well, the commission doesn't have to do anything with the $50 million trigger, and it doesn't have to do anything with the asset allocation. The rule says can't be more than 65% equities. And our witness is Dave Murray, and if you have questions about the stochastic methodology for the projections in the future, he's the guy to ask from us. And I'd be happy to try to answer any commission questions.
Mr. Williams, thank you. Any bench questions? Chair Hahn.
Staff counsel mentioned in his opening statement that the 65-35 equity bond mix has been approved in prior commission orders. What was OPC's position in those prior orders?
I have no idea.
Ms. Moore mentioned in her opening statement that there has been no analysis. I'm assuming she meant by OPC, but there's been no analysis of the tax implications of changing the equity bond mix. Has OPC conducted any of those tax analyses? And if so, would your witness be able to talk about that?
I think he can opine a bit on the tax analysis. I mean, we've accepted their 20% on the unrealized gains, and I think the evidence is going to show that if you look at the December 2024 filing, Ameren files quarterly. Well, they have quarterly filings. They may not actually file them quarterly. They're submissions to the commission about what the fund status is, and they have audited financial sheets. If you look at the December 31, 2024 dated filing, we believe the unrealized gain from that, it's about 700 million, I believe. And tax on that would be about the 143 million that you heard Ms. Moore say. Well, if you apply that against the fund balance, it still leaves about the same amount as they're saying the decommissioning costs would be in they call them $2023. I believe the study was, decommissioning cost study was as of June 30th of 2023, but there hasn't been a large passage of time. So essentially, they're about the same, if that helps.
And given that you're asking the commission to change the equity bond ratio to something other than 65-35, I haven't yet heard what you're asking the commission to change it to.
We are not asking it to change it to anything. We're telling the commission, don't approve the 65-35. We think it should be less risky. We don't have a number. And if the utility wants to, or the fund manager wants to keep the 65% equity, it can certainly do so. We're not asking that anything be done. But we would challenge the prudency if the corpus of, or the principle of the fund starts slipping down, so that it, basically the stock market's very volatile, and if it drops suddenly and it reduces that fund balance, we would raise prudency issues at that point if Ameren started coming in asking for additional customer contributions.
But you would even, I guess, would you still be able to do that if they retained 65-35 and the commission ordered that 65-35? You would still be able to would you be able to raise prudency concerns?
I don't know why we couldn't, but you would have a quote pre-approval from the commission saying 65-35 is the appropriate allocation. We don't think it is currently, but we're not saying what is.
Would you say that the customer contribution being now reduced to 0 is a result of the 65-35 contribution mix over time? Basically,
Sure.
the fund, okay.
I mean, there's a time when you want to grow the fund because you want to assure that you have sufficient funds to do the decommissioning. We're saying the fund, the principal in the account, the value of it, even after tax, if you were to go ahead and liquidate it now, should be sufficient based on their decommissioning cost study to have the funds you need to decommission Callaway in 2044. So the goal shouldn't be to grow the fund more. Any excess funds are going to end up getting returned to customers, but that's not going to happen until after the decommissioning. So you're going to have basically current customers giving a windfall to future customers. Again, the commission looks at this every 3 years. So things start getting out of whack, it can change what it's ordered.
Thank you.
Chair Hunt, thank you. Any further bench questions for Mr. Williams? All right, hearing none. Mr. Williams, thank you.
Thank you.
And I believe we're ready to proceed to evidence. Anything further before Ameren, Missouri puts on its witness for cross? All right, Ms. Moore, when you're ready.
Great, thank you. I'm called to the stand, Mr. Daniel Deschler.
And if you'll come forward to be sworn, please, sir. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Ms. Moore, when you're ready.
Yes, could you please state your name and business address for the record?
Yes, my name is Daniel Deschler. I work for Ameren at 1901 Shoto Avenue, St. Louis, Missouri, 63103.
And did you prepare direct testimony in this docket as well as a rebuttal testimony?
Yes, I did.
If I were to, did you have any corrections or changes to that testimony you'd like to make at this time?
No, I do not.
If I were to ask you the questions in both the direct and rebuttal testimony today, would your answers be the same?
Yes.
Now, I think I was giving Commissioner Mitchell an overview of the trust. Is there anything, and I said that B.Y. Mellon in New York was the trust manager. Is there anything in my statement that you would like to also clarify?
Yeah, I would just like to clarify, yes, Ms. Moore noted that BNY Mellon is the trustee for the assets, so they custody the 1.3 billion, using that number as of the end of 2024. The actual money is managed by two investment managers. On the equity side, it's a company called Nuveen Capital Management, and on the bond side, it's a company called Insight Investment Management. Insight is an indirect subsidiary of BNY Mellon. Those two managers have been managing these funds since day one, but I just wanted to clarify, because it's not, BNY Mellon is the trustee and holds and custodies the assets, but it's the two individual managers who actually manage the money.
And with that, I tender Mr. Deschler for a cross-examination.
Ms. Moore, thank you. Any cross from staff?
One question, Judge. Good morning, Mr. Dreschler.
Good morning.
And this is just kind of a clarification, has to do with opening statement earlier. Regarding the management of the trust fund, I think there was something in the opening statement regarding if the trust exceeds a certain level, the trustee will move those funds to fixed income securities. Did I hear that correctly?
Yes, it's not actually a trust. We will direct the trustee to move those assets, but typically the target equity allocation being 65%, we don't do it right with them, but generally if it goes up 3 to 5%, we'll start looking at reallocating the assets, and we'll direct the trustee. If in the case it's equity, we would direct the trustee to sell equities. That realizes a gain for which there'd be a tax due, but then those assets would be redeployed or reinvested on the fixed income side.
Okay, and that is a decision that would be made by Ameren.
That decision is made by Ameren, right?
No further questions, sir. Thank you for your time.
Thank you.
Mr. Pringle, thank you. Cross-examination, Mr. Williams?
Thank you. I have a few. First off, do we have any exhibits marked?
No, we do not at this moment. I can, do you want to move to mark or identify these exhibits now, or wait till after cross is done?
It might be a little cleaner to go ahead and do it now if you wanted to offer pre-file testimony.
All right, so I think it might also be helpful to offer the opening statement and the charts as Ameren Exhibit 1. And if we need to file that, we can go ahead and do that later today. And then the direct testimony of Daniel E. Deschler will be Ameren Exhibit 2. And the Sir rebuttal testimony of Daniel E. Deschler will be Exhibit number 3.
All right, and Ms. Moore, you're offering those in the evidence, is that correct?
That is correct. Thank you, Your Honor.
All right, exhibits 1, 2, and 3 have been offered into evidence. Any objections? Hearing none, exhibits 1, 2, and 3 are admitted into evidence. Mr. Williams?
Thank you. May I approach?
You may.
stipulation is exhibit number 4.
Okay.
You recognize it?
Yes, I recognize it.
Yeah, I'm sorry. Mr. Woods, can I trouble you to use the microphone for recording purposes? I apologize. We don't have a court reporter in the room.
Try it this way. Mr. Deschler, I've handed you what's been marked for identification as exhibit number 4. Do you recognize it?
Yes, I do.
And what is it?
It is the basically summary of assets for the Nuclear Decommissioning Trust as of 12/31/2024, which shows an aggregate combined market value of $1,342,170,000.
And I guess we'll do it as another exhibit. Pardon. This will be exhibit 5. I'm going to hand you what's been marked for identification as exhibit number 5. Do you recognize exhibit number 5?
Yes, I do.
And what is it?
It is again from the trustee, BNY Mellon. It's a statement of net assets available for benefits as of 12/31/2024. It shows the same value, $1,342,170,000.
Does it include more information than what's on exhibit 4 in terms of breakdown of assets in the fund? And I should say breakdown in terms of what is principal and what is unrealized gains?
Yes, it does.
And if you were, are the numbers there accurate to your knowledge, information, and belief?
Yeah, I believe the numbers are accurate, yes.
And if you take the unrealized gain portion, what's the amount for that? If it's not public, or if it's public information?
No, it's fine. It's 717 million.
And what would be the tax on that 717 million if you were to sell those assets, realize the gains?
Yeah, the NDT trust is subject to a flat 20% tax, so the estimated value of the tax would be around 143, 145 million if you sold all 717 million.
So if you were to sell the assets and realize, or pay the taxes, what would be the net value that would remain?
Well, it'd be the 717 less the 145 or so million in taxes.
No, I'm talking about if you take
Well,
the total
overall-
assets.
The overall value would be
Right.
1.198 billion.
And do you remember what the estimate is in 2023 dollars is how it was characterized for the decommissioning
It
costs
was,
of
it
Callaway?
was a little over a billion, it was $1.097 billion.
And these account summaries, are those something that BNY creates on a regular basis?
Yeah, they value the account monthly.
And do you make filing or submissions to the commission of those filings quarterly?
Filings are made quarterly to the commission, yes. By the trustee, they mail the trust statements.
So this would be something that the commission should have in its, as a submission?
Yes.
Sure how the best way to do that is. I could either offer, I guess, Exhibit 5 or tell the commission where it can take notice of the exhibit, use that as a copy. Is there a preference?
I think if you wanted to offer that, I would appreciate it.
Okay, I'll offer Exhibit 5, and if you want more copies, I can create those, but I don't have them currently.
Exhibit 5 has been offered. Any objections? Hearing none, Exhibit 5 is admitted into evidence.
I'll offer Exhibit 4 at this time as well.
Okay. Any objections to Exhibit 4? Hearing none, Exhibit 4 is admitted into evidence. Mr. Williams?
May I approach again?
You may.
Mr. Deschler, I'm going to approach and hand you what have been marked for identification as Exhibit 6, 7, 8, 9, 10, 11.
Okay.
Mr. Deschler, have you had an opportunity to take a look at what have been marked as Exhibits 6 through 11?
Yes, I have.
And what are they?
Exhibit 6 is the account summary, so the valuation of the trust as of June 30th, 2023, which shows a total value of $1,075,000,000. Exhibit 7 is again an account summary by the trust as of September 30th, 2023, with a combined market value of $1,041,000,000. Exhibit 8 is an account summary of the trust with a combined market value of $1,149,000 for the period ending 12/31/2023. Exhibit 9 is evaluation of the trust for April 30th, 2024, with a combined value of $1,188,000,000. Exhibit 10 is a market value of the trust as of June 30th, 2024, with a combined value of $1,266,000,000. And Exhibit 11 is a market value of the trust as of 9/30/2024, with a combined value of $1,332,000,000.
And do you recognize Exhibits 6 through 11?
I recognize Exhibit 6. Yes, that was what was filed with the original filing with the triennial filing, because we've based it on evaluation as of June 30th, 2023. And then Exhibit 11, is that what you asked me about?
Well, I asked actually about each one, so 7 through 11, but
Yeah, I mean, this form is what I generally see in the overall evaluation of the trust. So it comes from BNY, and I assume you got these from the filings that were made with the Missouri Public Service Commission.
so these are documents that are submitted to the Public Service Commission?
Yes. Yes, I will say, the one docket here says April 30th. It's my understanding that the docket submissions to the commissioner as of quarter end, so I would have expected March 31st rather than April 30th, but I don't know. I mean, I'm just making that comment. Generally, what gets filed is every quarter, and that particular exhibit shows an April 30th value.
Okay.
Yeah, I mean, it's just a month difference. I'm just noting that.
Well, if they were made as submissions to the commission's records, they'd be in the commission's records, right?
Yes.
And to your knowledge, you have no reason to believe they weren't submitted to the commission, do you?
I have no reason to believe they were not submitted to the commission.
In fact, you're confident some of them were. You recognized, at least I think it was was it 6?
Exhibit 6 I recognize because, again, that was the valuation of the trust. That was coincident with our filing in the fall of 2023.
I'll go ahead and offer Exhibit 6 through 11.
Any objections? Hearing none, Exhibits 6, 7, 8, 9, 10, and 11 are admitted into evidence.
Judge, I'll also represent that they are submissions that were made to the, copies of submissions that were made to the commission that if you need, I can give you where to find them. Well, actually, public counsel filed objections to the stipulation and agreement, and there's, I think it's a footnote that has links to these particular documents. I think I have no further questions at this time. Oh, one thing. Are any of these exhibits, that'd be 4 through 11, confidential? Commission requires, or treats submissions as confidential, so they're designated that way currently. I don't know if they need to be confidential or not.
They're not necessarily confidential.
Thank you. I have no further questions at this time.
Mr. Williams, thank you. Let me see if we have any bench questions. Chair Hahn, any questions?
Good morning.
Good morning.
If you would, could you talk me through how we got to the $50 million trigger in this case? Why 50 million, or what was the rationale behind the number?
Okay. Yes, I think it's an excellent question. The 50 million is kind of a rough number. It represents roughly 5% or so of the value of the trust. Why we came to that number is I think it's consistent with the law, which says you shall neither overfund or underfund the trust. So in trying to make sure we maintain parity with customers, we don't want to let the trust fall. If the underfunding value fell so fall, then, when we would request a reinstatement of contributions, it may unduly burden current ratepayers versus future ratepayers. So I can't say there's any precise science to it, other than we're thinking, let's try and put a 5% window on it. Let's take a look at it. As was noted in the opening statements, it doesn't guarantee that we would reinstate the contributions, but it would just be a recognition that Ameren would like to pursue reinstating contributions if, in fact, the value of the trust were underfunded by 50 million or more.
Thank you. Changing issues a little bit to the equity bond ratio. Given OPC's position, did Ameren model any other equity bond ratio other than 65-35 for maintaining a trust fund balance moving forward?
Yes, we did. We engaged a consultant, Willis Towers Watson, who is our pension consultant. And one of the first things they did is they did an asset liability modeling study. So they look at the liability side, which is the cost of decommissioning. They look at the asset side. And they looked at various mixes, and this was submitted in the original testimony that was filed, amended filing in March of 2024. But it showed the various, what we call efficient frontier positions. So it's looking at the different positions in fixed income and equity. And a 65-35 was the ideal point, because that's the point at which you maximized, or you had the highest degree of probability of success of funding the decommissioning at the time of decommissioning with that 65-35 mix. If you increase the equity mix, you didn't really appreciably increase that probability. And if you decrease the mix, then you began to decrease the probability that you would have enough funds associated with it. So it was an analysis that Willis Towers Watson, our consultant, did. So they support, the recommendation to continue the allocation of 65% equities and 35% fixed income.
To your knowledge, has OPC conducted any similar analysis that you've been able to review on changing the equity bond ratio?
I've not seen anything from OPC in that matter.
Thank you.
Chair Hahn, thank you. Any further bench questions for this witness? Hearing none, I'm going to have a few questions, and spoiler alert, I will probably be asking very similar questions to the other witnesses, so I just wanted to prepare you for that. And Mr. Deschler, if you've already answered a question I ask you, please let me know. I'm not trying to be repetitive. I think the questions I have will not be repetitive, but if you've already answered them, please let me know. What is the projected decommissioning cost for Callaway and the independent storage installation site at the end of the current license?
Okay, the cost was prepared by TLG, who's a third party that we contract with. Projects the cost in current day dollars, so at the time we engaged them, they projected the cost in 2023 dollars. And that combined cost for both plant and IFSC was $1,097,900,000 and some odd thousand.
And what's the appropriate current amount for ratepayers to contribute to the trust fund, for that fund to have neither greater nor lesser than the amount necessary to carry out the decommissioning of Callaway and the independent storage installation? And that would be at the end of the current license, I think, in 2044.
Well, I think the answer to that question is in two parts. At the time of the filing in June of 2023, our position was to continue with the current $6.75 million a year in ratepayer contributions. Okay. Since then, and we revalued things as of the end of 2024, and we took the market value of the trust, adjusted it for taxes, and I know OPC's brought this up, looked at the value of that in relation to an escalated cost of decommissioning, and we were slightly over 100%. So we agreed to suspend the contribution at this point in time. So as of now, and what's agreed to here in the stipulation is we agree to suspend the contribution, so to go to zero at this point in time.
The company's amended application had an attachment 4 that presented the results of some WTW modeling. Do you know what annual customer contribution that modeling assumed?
It assumed a $6.75 million.
And what modeling or analysis was used to support reducing the annual ratepayer contribution to zero?
Well, we did not redo the stochastic modeling that you're referring to there. What we did was we took the 12/31/2024 valuation, which we recognize as $1,342,000,000. We adjusted it for taxes because if we were to try and spend that money to decommission Callaway, we'd have to realize all those unrealized gains and pay taxes on that. So on that value, we took an after-tax market value, and I believe it was $1.19 million. And then we compared that against an escalated, and I don't remember the number specifically, but an escalated cost of decommissioning from the $1,097,000. We escalated it and compared those two numbers. And the value of the trust as of 12/31/2024 on an after-tax, so tax-adjusted basis, was slightly higher. It was like 103% over the cost of decommissioning that we estimated. We didn't go back and ask TLG to redo their estimate. We just kind of used some escalation factors. So that's why we agreed to suspend the contribution at that point.
What asset allocation was used in that analysis?
Well, it would have been the 65/35 because it took the valuation of the trust as at that point in time. That hadn't been changed.
And why is it reasonable for the trustee to continue to maintain the allocation of 65% equities and 35% bonds when the trust balance is sufficient to cover the estimated decommissioning costs?
Well, I think it's prudent. Number one, our consultant agrees with us, so they're very knowledgeable in the industry. But I think it's prudent for really two considerations. Number one is the runway is still long. I mean, even if we talk about the current license termination of 2044, we're talking 19 years. I think generally people invest over that time period when the runway is long. You tend to invest using more equities than bonds. And again, that was what was reinforced in the analysis as well as Tyrus Watson did. The other reason I think it's prudent to continue in that manner is that although we can estimate the cost of decommissioning today, and we have, and TLG's done that, and we can use certain escalation factors, we don't know if, I mean, that risk, that cost or that risk is still an unknown of sorts. There could be things that, cause it to be more expensive than we forecast. So our position is, as is in the law, to maximize return, on the assets to prevent the possibility that we would not have enough money at the time of decommissioning. So, so that's why we think it's still prudent. And if you recall in the original filing, the probability analysis showed that there was a 67% probability that we'd have enough funds. So still is an outside chance we wouldn't have enough funds given certain market assumptions. The stochastic modeling, does all these assumptions around inflation, interest, rates of return. And so given certain, market assumptions, there could still be the case where there'd be some funds necessary at the time of, be underfunded, I guess is a better way of saying it, at the time of decommissioning. So for those reasons, we still think it's prudent. And it doesn't hurt the customer in any way because we're maximizing the return on these assets over the long run to keep the asset allocation of 65-35.
For the next triennial filing, would there be some value for the parties to define some agree to alternative asset allocation as input to the modeling prior to WTW performing its analysis?
I'm not sure what you're asking me for there. Are you asking that we agree up front to how to model the next filing?
Or perhaps discuss it if there would be an alternative mix?
I would be open to discussing with OPC or staff on how to do the next filing without restricting our ability to use the advice that Willis Towers Watson would give us.
In the non-unanimous stipulation and agreement, I believe paragraph 9 states recognizing that the company shall request reinstating customer contributions to the fund if the trust fund is estimated to be underfunded by an amount greater than $50 million at the time of the next triennial filing. What would be the benefit in the commission approving a trigger amount to be activated at the next triennial filing?
I think the benefit is just a recognition that we intend to try and maintain adequate funding for the trust so as not to unduly burden current customers or future customers. I mean, we certainly don't want to let the trust get to a point where, it's considerably underfunded and we're forced to, make greater contributions with current customers or, I guess, yeah, that's all I'm saying is we just don't want to get to the point where, we unduly burden current customers versus future customers. So the 50 million seemed like a reasonable trigger point.
Would the trigger activate between triennial filings or just at the time of the triennial filing?
I think the 50 million would only be at the time of triennial filings. I'll offer this, we continually monitor the trust. If we thought that the fund was considerably more underfunded, then I guess we may petition prior to a filing, but I think generally it would only come in the form of a triennial filing.
Right, thank you. I think those are all the questions that I have. Let me see if we have any recross based on bench questions, any recross from staff.
No recross, Judge. Thank you.
Thank you. Public counsel?
Yes, thank you. Why are you requesting the commission to approve a 65-35 asset allocation? Doesn't the commission rule allow you up to 65% equity?
The commission, are you saying the rule, the rule?
I'm just asking, why is Ameren requesting that the commission issue an order saying, yeah, 65-35 asset allocation between equities and bonds is appropriate?
Well, I think we've requested that at all the prior hearings, as was noted earlier, since 2012, I believe. So we just thought it was a matter of, routine, document. In fact, this is how we intend to manage the assets going forward. So I think it's consistent with that approach.
Well, with the rule, you can manage the assets any way you want up to a 65-35 allocation, right?
Our current investment guidelines, which have been submitted in part of prior hearings, say, yeah, the asset allocation would be 65-35.
You're not familiar with the commission's rule?
Are you referring to 65% of book value?
Yes.
Okay, book value, I am familiar with that rule. Book value in this case really doesn't apply because the rule that I think OPC is referring to says that the value of the assets shall not exceed 65% of the book value in equities. The equity allocation should not exceed 65% of the book value. Am I correct in your assumption?
Yes.
Okay. Book value is looking at the, and you'll see it in the trust statements, looking at the sum of the customer contributions plus the realized gains, and it's about 600, as of 12/31/24, it was about 600 million. Okay? Equities are, far less than that. So my point is that book value rule was put in place, I believe, I wasn't around, but I believe it was there to control that at the time the initial contributions were putting in place, that we wouldn't over allocate any principal contributions to equities. The current equity allocation on book value basis is far less than 65. It's in the 25 to 30% range. And it'd be highly improbable that it would go up and exceed the 65%. So I think what's important to clarify here is the rule says book value, not market value. And again, although I wasn't around at the time the rule was put in place, the way it makes sense to me as an investor is that the rule was put in place to make sure that at the time we were initially funding the trust, that we weren't putting 100% of the money into equities, which would have been, contrary to that rule, because you would have had 100% in book value versus the constrained 65%.
And isn't part of the guidance also, I don't remember if it's statutory or rule, but to conserve the principal of the fund?
I'm not sure exactly what you're referring to. Can you refer to?
Well, you talked about the guidance to grow the fund.
Right.
Isn't there also guidance to conserve the principal of the fund?
I'm not familiar with that particular. I'm familiar with you shall invest the assets to maximize return, but I'm not familiar with the reference to conserve principal. I'm not saying we shouldn't conserve principal, but I'm not familiar with that reference in law.
I think it's the following clause, but it is what it is.
Would you like me to provide a copy to him?
No, that's fine. No further questions, thank you.
Mr. Williams, thank you. Any redirect?
No, Your Honor.
All right, thank you. All right, Mr. Deschler, thank you very much. You may step down. You may. And then, Ms. Moore, does that conclude Ameren's evidence?
That is correct, Your Honor. Thank you.
All right, Mr. Pringle, when you're ready with your witness.
Yes, Judge, and just to make sure I have the right numbering for exhibits, my count was 11 was the last one, so staff will start with 12, correct?
Correct.
All right. Then staff calls Mr. Randall Jennings to the stand.
All right, Mr. Jennings, if you'll come forward, be sworn, please, sir. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you very much, sir. You may have a seat. Mr. Pringle, when you're ready, sir.
Thank you, Judge. Good morning, Mr. Jennings.
Good morning.
Could you please state and spell your name for the record?
Randall Jennings, Randalljennings.
And Mr. Jennings, by whom are you employed and in what capacity?
Public Service Commission. I'm currently a research and data analyst for Tariff and Rate Design Department, but for the purposes of this hearing, I was previously a senior utility regulatory auditor in the Financial Analysis Department and Financial and Business Analysis Division.
Thank you for that, Mr. Jennings. And are you the same Randall Jennings who authored what have been labeled as staff exhibits 12, 13, and 14? Exhibit 12 would be staff's recommendation. Exhibit 13 would be your rebuttal testimony. And Exhibit 14 would be your surrebuttal testimony.
I authored the memorandum in support of the staff recommendation, yes. And also the testimonies, yes.
Yes. And do you have any corrections to make to any of those documents at this time?
Not that I'm aware of.
And if I were to ask you the same questions within your, well, if I were to ask you the same questions, would your answers be substantially the same or similar to what is within those documents?
Yes.
Thank you, Mr. Jennings. At this time, Judge, staff moves to enter exhibits 12, which is staff's recommendation, 13, which is the rebuttal testimony of Mr. Jennings, and 14, which is the surrebuttal testimony of Mr. Jennings.
Mr. Pringle, thank you. Exhibits 12, 13, and 14 have been offered. Any objections?
I don't know that it, well, let me ask the scope of what you're offering in terms of the staff recommendation. Are you offering the entirety of the document, including the pleading portion or the memorandum?
The memorandum.
No objection to the memorandum.
All right. Hearing no objection, Exhibits 12, 13, and 14 are admitted into evidence.
Thank you, Judge. And at this time, staff tenders Mr. Jennings for cross-examination.
Mr. Pringle, thank you. Cross-examination, Ameren. Ms. Moore.
No questions. Thank you, Your Honor.
Mr. Williams.
Thank you, no.
Right. Any bench questions? Chair Hahn.
Morning, Mr. Jennings.
Good morning.
I asked this question also of Mr. Deschler, but I was hoping that you could also give me your recollection of how you arrived at the $50 million number, if it was similar to what Mr. Deschler testified to.
That number came solely from Ameren. Staff had no input on that number.
Okay, given that, do you find that the $50 million trigger is appropriate? Why or why not?
Staff did not object to it, didn't really see a reason to object to it, or really support it one way or the other. So,
Thank you.
sorry.
All right, thank you. Any further bench questions? All right, hearing none. Mr. Jennings, I'm going to go through the list of questions that I kind of went through with Mr. Deschler. What's the projected decommissioning cost for Callaway Unit 1 and the independent storage installation sited at Callaway at the end of the current NRC license?
I believe in 2023 dollars, roughly 1.1 billion.
And what's the appropriate current annual amount for ratepayers to contribute to that trust fund, for that fund to have neither greater nor lesser than the amount necessary to carry out the decommissioning of Callaway Unit 1 and the independent storage installation unit?
Based on the non-unanimous stipulation and agreement, 0.
And I believe attachment 4 to the amended application presents some results of WTW modeling. What annual customer contribution did that modeling assume?
At that time, it still assumed the 6 million, roughly 6.7 million annually.
And do you know what modeling or analysis was performed to support reducing the annual ratepayer contribution to 0?
I don't know that there was any additional modeling in support of that.
Is it reasonable for the trustee to maintain a trust fund asset allocation of 65% equity, 35% bonds, when the balance is currently sufficient to cover the estimated decommissioning costs?
I don't believe staff has a position on that because the rule just simply says a maximum of 65%.
At the in the non-unanimous stipulation in paragraph 7, that stipulation states, unless the signatories agree to use a different source or different methodology for capital market return expectations. So does that statement mean that the signatories can change the source or the methodology for capital market return expectations without approval from the commission?
It was paragraph 7.
Yes, I believe it should be at the end of page 7 and going on to page 8.
As I understood it, that was for modeling purposes. Again, the rule allows them, allows the trust manager to do whatever allocation they deem appropriate, as long as it doesn't exceed 65% equities.
All right, thank you. I believe those are all of my questions. Any recross based on bench questions? Ms. Moore?
Yes, I just have one. If the commission didn't adopt a $50 million trigger, would the company be able to come back and argue for reinstating the contributions?
Upon their next triennial filing, yes.
Yeah, so customers would benefit, would you agree that customers would benefit? They would have a longer period of not paying any contributions if the decommissioning costs increased and the value of the fund remained the same?
Customers would have a longer period of no contributions given the trigger, as long as the trigger's not met, correct?
And so there would be a customer benefit in that respect. Would you agree with that?
I don't know that I would call it a benefit. I can simply say that they would not have any contributions.
So they'd be paying less,
Correct.
and a lower rate isn't a benefit?
Yes?
I have no further questions.
Once more, thank you. Mr. Williams,
Thank you, no.
any redirect?
No redirect, Judge. Just simply ask that Mr. Jennings be excused from the stand.
All right. Mr. Jennings, thank you very much. You may step down.
Thank you.
And I believe we are now off to Public Counsel's witness, Mr. Murray.
Yes, public counsel calls David Murray to the stand.
All right, Mr. Murray, if you'll come forward to be sworn, please, sir. Do you swear the evidence you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you very much, sir. You may have a seat. And Mr. Williams, when you're ready.
The next exhibit's 15, is it not?
That's correct.
Mr. Murray, did you well, first, would you please state your name for the record?
It's David Murray, last name spelled M-U-R-R-A-Y.
By whom are you employed and in what capacity?
Office of Public Counsel as a utility regulatory manager.
Did you prepare what's been marked as Exhibit 15, which is rebuttal testimony of David Murray, that was pre-filed on November 8th of 2024, and then amended, or a schedule DM-R-5, was submitted on, or filed on January 22nd of 2025, because you'd attached an incorrect schedule to the November 8th filing. Did you prepare that testimony and cause it to be filed?
I did.
And is Exhibit 15, including the amended schedule DM-R-5, your testimony here today?
Yes.
You don't have any changes or corrections to any of it?
No.
With that, I'll offer Exhibit 15.
Exhibit 15 has been offered. Any objections? Hearing none, Exhibit 15 is admitted into evidence.
And I tender Mr. Murray for examination.
Mr. Williams, thank you. Any cross from staff? Mr. Pringle.
Yes, Judge, thank you. Good morning, Mr. Murray.
Good morning, Mr. Pringle. How you doing?
Pretty good, pretty good. Thank you for asking. Just one question for you. Are you aware of what OPC's position was in the past regarding the inclusion of the equity bond allocation in a commission order?
I believe the public, I started working with Public Counsel in 2019, so there might have been one other decommissioning triennial filing since I've been there, but I think we just did not oppose prior stipend agreements, if I recall correctly.
All right. Thank you very much, Mr. Murray.
Thank
No
you.
further questions.
Mr. Pringle, thank you. Ameren, Missouri.
No questions. Thank you.
Right, thank you. Any bench questions? Chair Hahn.
Good morning.
Good morning, Chair.
Good morning. Thank you, Mr. Murray. I also want to ask you about the $50 million trigger. So it was suggested by Ameren that there was a 5% of the total fund as kind of how they arrived at the $50 million number. But my question really is, if the commission doesn't approve a trigger, when is the next time that Ameren can go to reinstate the customer charge?
They can request, any triennial filing, basically, and I think that's the purpose of having them come in every 3 years, is to monitor the status of the fund. So they could request at any time, whether or not, parties agree and the commission ultimately approves is to be determined.
And is it the purpose of the $50 million trigger to ensure that the fund doesn't get out of balance before the triennial filing? Because I'm guessing that OPC's position is opposed to the trigger, so I'm trying to understand why.
Okay, yeah, I can't, as far as the 50 million, because that was not, OPC was not involved in that negotiation. So I don't have, knowledge as to what the magic was with the 50 million. But as far as OPC is concerned, and this is, outlined in my testimony, that even when the Nuclear Decommissioning Trust Fund balance of assets was 100 million less than the cost to decommission Callaway nuclear facility and the ISFC, that there was no need for contributions at that time. And that's because you have 20 years of additional time horizon for compounding of returns. And so, yes, and OPC relied on the Willis Towers Watson probability forecasting model, the stochastic modeling, that predicted that the fund has a 67% probability of successful outcomes. So that 67% of successful outcomes includes, at the minimum, meeting the exact cost of $1.097 billion, all the way to quite excessive surpluses in the fund. And so that was the basis. In my testimony, my basis was that actually, if you're to be consistent with the statute, you should have an equal probability of over and underfunding. And because it says neither more nor less than necessary to defray the cost of decommissioning. So my point is that, yes, I would not agree with the 50 million. I would not agree with any trigger, because based on even before the stock market did quite well in 2023 and 2024, which got us to this, over funding balance, that there was 20 years to continue to compound returns over and above inflation, which had a 67% probability of minimum to excessive funding.
Thank you.
I'm sorry, can I
I'm just,
clarify?
if in the period between triennial filings, the fund would underperform, the public counsel would be okay with that, and then at the next triennial filing, look at changing the customer charge accordingly at that point. I'm wanting to try to understand why there's, because it seems like it could have the customer impact could go either way. It could be good for customers to keep the $0, but if you wait till the triennial filing and you have to reinstate that customer charge, it could be higher. So I'm trying to understand the opposition to the $50 million trigger.
Well, because Office of Public Counsel, my position and the Public Counsel's position is that even the goal should have never really been to get to 100% funding as soon as possible, which is what we're at. We're at 100% funding in 2024, 25, with 20 years to go. So the customers that get to use the generation from Callaway for the next 20 years do not have to, in Public Counsel's opinion, they should not contribute any additional funds because you've met your goal. The goal has been met to achieve the amount necessary to decommissioning Callaway. Now the goal is just to make sure you cover inflation. So with that being said, the portfolio balance in and of itself, and as you pointed out, I have not recommended a specific asset allocation, but it should be to maintain the real purchasing power of the current fund balance, because we're here, we're there. And so I cannot see of any situation where if you don't expose yourself to excessive risk, where you're going to be in an underfunded status at this point in time. But in the next, so what I'm saying is, I don't think anything is going to occur in the next year or two that's going to be devastating, even if you agree with the company's position. And just, obviously, people are aware that in April, we had quite a bit of volatility, and we still have volatility in the stock market. And there was a period at the trough of the significant sell-off in stocks, and specifically the S&P 500, which is the equity portion of Ameren Missouri's Nuclear Decommissioning Trust Fund, where it was down 15%. And that would have, based on my calculations, based on my estimate, which is not in evidence other than what I'm speaking about right here, that would have caused a trigger. But, there's going to be ebbs and flows. And I know folks, if you follow the the convention that you buy when stocks are low, then you would have contributed more because you think the returns are going the stock market's going to come back up. But who knows? I mean, nobody knows for sure. Over the long term, you hope that that's going to be the case, and that's the key. Is we have 20 years, and we're already funded. So the next 20 years of stock market returns. You're going to, based on what I reviewed, you have a much higher probability of having surplus funding if you continue, specifically if you continue the contribution of the $6.7 million. And those ratepayers have not paid $1 or may not end up paying $1 in contributions to the Nuclear Decommissioning Trust Fund, but they got the benefit of the energy. And then they'll get the refund in 2044 if it terminates in 2044. 2064, if it gets extended another 20 years, you could have a potential huge amount of excess funds that get refunded to ratepayers that didn't pay a dime into the Nuclear Decommissioning Trust Fund.
Thank you, Mr. Murray. Appreciate that. One other thing, tell me why you didn't make a recommendation other than 65-35, because for the commission to order something less, it seems odd that we wouldn't have a recommendation based on some modeling. So can you walk me through that?
I'll be quite honest. I'm not an investment manager. I'm not a portfolio manager. I don't. I have my opinions, but it needs to be carefully thought out. I think the rule when it was created anticipated a 40-year license, so the termination would be in 2024. I don't think the rule anticipated continued extensions, and what do we do if we get to full funded status 20 years before the license, the extension. I don't think the rule anticipated that. And so whenever it says 65-35, maximize, maximize the returns but preserve principal, that's when you're growing the fund. At this point, you just need to preserve the purchasing power of the fund. And so my point to that is while there are considerations that should be made in potential de-risking and not causing a capital loss, because if you're, right now we're about 100, well, as of December 31st, 2024, you're 100 million overfunded. Today, we have 20 years left. Why wouldn't you be taking, considering right now ways to preserve that capital and at least maintain the decommissioning cost inflation rate, which, and that's another thing that I try to emphasize is very important. That decommissioning cost inflation rate that's assumed really drives what the required return is going to be for the next 20 years. I've seen it, there's estimates as low as 3 to 3.3% with the Wolf Creek Decommissioning Trust Fund, and then for purposes of Ameren, Missouri, in the Callaway plant, there's a decommissioning cost inflation assumption of 4.7%. I've never seen it that high, and so that drives what the required return is going to be. And so that makes a big difference of compounding over the next 20 years. So yes, that should be something that is, I believe there's a nuclear trust fund committee. I know there was with Wolf Creek. I'm trying to remember with Ameren as far as monitoring the status of the fund. But yeah, I have no problem with them working with Willis Towers Watson and say, if we want to make sure we don't have capital losses and just capture enough return to meet the decommissioning cost inflation, a reasonable decommissioning cost inflation rate, what's the best way to do that?
Thank you. Appreciate that.
Thank you.
Chair Hahn, thank you. Any further bench questions? Right, hearing none, Mr. Murray, I'm going to have similar questions for you that I had for the other witnesses. If you've already answered a question, please let me know. I don't mean to ask you to repeat yourself.
Thank you.
What is the projected decommissioning cost for Callaway Unit 1 and the independent storage installation unit cited at Callaway at the end of its current NRC license?
And I think that was, something I wanted to add to, because you asked that question of the other two witnesses, and you're asking as of 2044, and that is a very important distinction. As of 2020, June 30th, 2023, it's 1.097 billion. What it's going to be in 2044 depends on the decommissioning cost inflation rate you apply to that. I said Wolf Creek, it's been as low as in the low 3% range. With the Callaway, assumptions, it's all the way up to 4.7%. If you use the 3.33%, or, something similar to what Wolf Creek, assumed, it's 2.2 billion in 2044. If you use a 4.7% decommissioning cost inflation rate, it's going to be about 600 million more, 2.8 billion, somewhere in that ballpark.
What's the appropriate current annual amount for ratepayers to contribute to the trust fund, for that fund to have neither greater nor lesser than the amount necessary to carry out Callaway's decommissioning at the end of its license life, which is October 18th, 2044?
In my opinion, it would be negative, but that's not possible.
The company's amended application, attachment 4, contains some results of WTW modeling. Do you know what annual customer contribution the modeling assumed?
The 6.7 million.
Are you aware of if any modeling or analysis was performed to support reducing the ratepayer contribution to zero?
I used the modeling to recommend zero. I recommended zero even before it was, the fund had gotten to 1.3 billion. So additional modeling and additional assumptions, none that I'm aware of. But I used the modeling, but done by Willis Towers Watson to interpret what the results were.
Is it reasonable for the trustee to continue maintaining an asset allocation of 65% equities, 35% bonds, when the balance is sufficient to cover the estimated decommissioning costs?
I think that needs to be evaluated. I don't have an answer. You have to look at correlation coefficients of all sorts of different securities and classes of securities. You have to look at what's the best way to protect against inflation, the degrading of your purchasing power. I think it should be looked at to be de-risked. What that entails, that would require more research and from folks that actually do portfolio management.
Were there any other fund asset allocations considered in the various modeling?
I didn't see any.
I think those are all the questions I have, Mr. Murray. Thank you. Any recross based on bench questions from staff? Mr. Pringle.
Yes, Judge, thank you. Mr. Murray, in your opinion, do you think that inflation is the only factor that could cause the cost of decommissioning to go up?
No.
Do you think that perhaps increases in labor and supplies could also cause that cost to go up?
Well, that would be part of the decommissioning cost inflation. I mean, it's labor, energy, materials. That's part of the formula from the NRC.
And when it comes to the inflation rate, do we know what the inflation rate is going to look like in 5 years?
There's a specific formula directed by the NRC on how to estimate decommissioning cost inflation. That's all I can tell you is they rely on authoritative sources to project inflation, which they project out to 2050.
But it's fair to call those are projections or assumptions, correct?
Yeah, anything in the future is projection.
Thank you, Mr. Murray.
Mr. Pringle, thank you. Any recross Ameren, Missouri?
No, thank you, Your Honor.
Thank you. Any redirect, Mr. Williams?
Thank you. Mr. Murray, do you know if there's any reason why Ameren or maybe staff couldn't come in and earlier than a triennial review and ask that there be a change in customer contributions?
I'm not aware of anything that prohibits that.
Are you familiar with the commission's decommissioning rule?
I am. I don't have it memorized, but yes.
Well, doesn't it provide that it basically direct the commission to conduct a review every 3 years, but it doesn't direct anybody else about what they are or are not to do, does it?
No.
And there was a lot of discussion about the 65-35 equity bond asset allocation. Why, would you explain why you did not propose any particular asset allocation as opposed to that 65-35?
Again, I'm just recommending that there should be some more comprehensive evaluation of what's appropriate once a decommissioning trust fund achieves the goal of being fully funded. And my recommendation in my testimony was that it should be evaluated for de-risking. I didn't have a specific portfolio recommendation.
Well, in your opinion, is there enough evidence in the record before the commission for it to do that?
No.
No further questions.
Mr. Williams, thank you. Mr. Murray, thank you very much.
Thank you.
You may step down. And I believe that concludes our evidence. Is there anything further from council? Or anything further from the bench? All right, hearing nothing, we will look forward to the parties' post-hearing briefs. If there's nothing further, we are off the record. Thank you very much.
Thank you, Judge.